Welcome to the fine art of disinheriting an heir. I am Jim Cunningham. We're going to talk about some effective legal tactics to make that happen. I've got Randy Catanese joining me here today, and we have a lot of ground to cover. And Randy, any initial thoughts on what we're going to be talking about?
Well, it's interesting. You'd think this is a very simple idea, meaning I'm not going to leave something to somebody in my family or otherwise. But as I think our listeners and people watching will find out today, it's a little bit more complicated than you would think. And so I think what we're going to present today should be very beneficial to those who are watching and listening.
Well, that's a shocker because it's California. Of course it's complicated. So one thing,
Nothing easy.
Right, it ain't easy.
There's nothing easy. It's not even easy to say, I'm not giving you my property.
So this is very important, guys. This is a disclaimer. Do not rely on this for anything, okay? This is information. This is the farthest thing from legal advice. And I say that, in kind of a not a joking manner, but I'm really serious about this. Of all the videos that you're watching, this is the one where you're probably going to want the most legal counseling. This is our team of lawyers here at Cunningham Legal. We've got 7 lawyers in offices throughout California. And we do have our YouTube page. So go ahead, if you're watching this on YouTube, go ahead and subscribe on our YouTube page to stay abreast. We got a lot of changes coming up this year. We've got, Prop 19 is becoming effective. We're currently at the end of January. That's becoming effective next month. Then we've got the Biden tax increase. And so Biden has said, hey, I'm going to spend a lot of money in the spring and we're going to raise taxes in the fall. So if you're concerned about that, subscribe to our page our YouTube page, because we'll have a lot more videos on that. Also, if you're here live, there's a Q&A button. Go ahead. It's the black bar there on Zoom. You can click Q&A and put your question in there, and then we'll go ahead and answer that as we go through the materials. I want to introduce Randy Catanese. I've known Randy, 20, 25 years. He's from Catanese Wells in beautiful Westlake Village. And we're here to discuss estate conflict resolution. And there are valid reasons to disinherit somebody. There are also potentially invalid reasons to disinherit somebody. We're going to talk about what that looks like. And then really, how do you disinherit somebody in California? What do you do? And this really is geared for lawyers and non-lawyers. We have a lot of lawyers that attend our webinars and watch our videos on YouTube. And so we're kind of giving you like the bird's eye view, kind of there's some law in here, but this is really just kind of the collective experience of Randy and I throughout our careers, and how to avoid malpractice liability in the process. Because unfortunately, the big M word, right, Randy? Do you see malpractice liability? I mean, I see those are the cases, right?
Well,
that's really the only time you're getting sued. Yeah,
you have to be careful here, and we're going to talk about, where do your duties run? Who is it that you have a responsibility to? And if you're a lawyer, as we all know, any liability is going to arise from the relationship, attorney-client, or what we call privity of contract. And so you want to be careful when you're dealing with whoever it is that has the property, or other people, family members, friends, whomever, charities, who have been told you're going to be getting some of this property. And as the lawyer, you got to be careful how you say things, when you say things, what you disclose, because when you make a statement or you start to do things in furtherance of someone's agenda, there could be the claim made later that they felt you were representing them. And under the state bar rules, you don't have to have a formal legal engagement letter to be found to be in an attorney-client relationship. We'll get into more details on this later, but that's just some of the early stuff you just want to be aware of and be concerned about.
So, hey, here's how here's how we can help you. Most people want to leave what they have to the people they want in the manner they want to secure a legacy for them. And we're here to help you craft a plan, give you some options, make recommendations that are part of an integrated estate plan to accomplish your estate planning goals. And this leads to more wealth for yourself, your family, and your loved ones. So that's basically estate planning in a nutshell. But what if there is somebody, Randy, and we do see this, we meet with clients and they say, I want to disinherit my daughter. I want to disinherit my son. And what is the first thing we ask them? Why?
Well, the thing that happens a lot, Jim mentioned earlier, Jim and I have been involved in these cases, honestly, 30 plus years, more than 25. And for a lot of you out there, the lawyers that do this, you know, this was what normally happens. Somebody will come in your office and here's what they'll say. My daughter hasn't talked to me in 5 years and I don't like her husband, so I don't want to leave her anything. Or if I do leave her anything, I just want to leave her a token amount, $1,000. But then on the same breath, you get something like this. However, my son, who's been living with me and been taking care of me for the last 5 years, well, I want to leave him everything. And right away, when you hear that, in my mind, what I start thinking is there undue influence happening here? Does this person have capacity? Is there something going on where there's somebody whispering in their ear to the detriment of the daughter or the sibling? So keep in mind that when you have this notion of a client coming in saying, I want to disinherit or I don't want to leave something, in the first instance, it doesn't usually happen when they're young. You know, when they're in their 20s, 30s, 40s, 50s, even 60s, they're not really talking about this that much. But as they age, then things that creep in might be a second marriage. It could be that the second wife, the second husband starts whispering. And normally there might be a pre-existing trust or will or estate of some sort. And so when this starts to happen, it's very important, Jim mentioned this earlier, as the lawyer, you need to start saying to yourself, who do I represent? Who is it that I do not represent? And what level of inquiry do I need to undertake right now to determine if something bad's going on, either in the home, outside the home, or what have you. So those are just a couple of things that it's always, like I said, it's not so easy when somebody says, I don't want to leave something to my daughter or my son or another family member.
Yeah, you know, it's interesting. You mentioned the stepmother. That reminds me of the feature length, sort of older Disney animated films where there's no mother. Like all the mothers are dead in the films, and it's always the dad and the evil stepmother, right? And
yes,
and that I think is an archetype in Western culture, is this evil stepmother. You know, my true mother died, and now there's this stepmother in here who's treating me like dirt, even though she may be younger than me. Okay. So consider these factors before disinheriting. I think I try and talk people when this subject comes up, I really do frankly try and talk them out of disinheriting their kids. Because what I'm thinking about is, number one, why? And then when you're gone, is your family going to even want to get together for Thanksgiving? Now, if they're not getting together for Thanksgiving anyway, because they hate each other, okay, you know, enough said on that. But think about the legacy. There are also protected classes: race, gender, sexual orientation. Clearly, race is a protected class in the United States. It's protected by the Constitution. Gender, sexual orientation is moving that way. And I think there was, Gorsuch wrote the opinion recently that I think sexual orientation or gender is a protected class as well. That was a recent case. And then what the law says versus the lawyer's role as counselor. You know, lawyers have we're in these two worlds. We're in the world of like, what's the law? And we tell our clients, okay, this is what the law is. But then on the other hand, there's a counseling aspect. And, you know, sometimes I feel like a psychiatrist sometimes. What about the right to sue versus the right to inherit? We'll talk about that. You know, a lot of people are surprised. They say, well, isn't it my decision? Can't I just not leave my kid something? And shouldn't that be it? How is it that they have the right to go to court? How is it that they have the right to sue? So we'll talk about that. Something else to bear in mind: if you are the trustee and your parents have disinherited one of your siblings for an invalid reason, you still have to follow the terms of the trust, okay? Whatever the terms of the trust are, unless it goes to court. I mean, Randy, you want to fill in the blanks on that one? I mean, I'll tee this up as an example. They say, my son's gay. I don't agree with his lifestyle. Because he's gay, I'm disinheriting him and I'm leaving it to my other 3 kids. And then the 4 kids get together and they go, well, that was dad. You know, you and your husband, we're all like a tight family. We, still get together for Thanksgiving. Can they intentionally violate the terms of the trust? How does that work?
Well, one of the things that I really want to emphasize to everybody out there, I will speak at different groups. One of the groups I speak to from time to time is Conejo Valley Estate Planning Council, which I helped start. And what happens many times for those in the audience who are the lawyers drafting the trust, drafting the will, many times the discussion is, okay, here's how we're going to do portability. Here's how we're going to address Proposition 19. Here's how we're going to do
Right.
this. But what people don't understand is when you get to the courthouse, the judge sitting in equity, and equity is going to be where the court is administering justice over a trust, a will. The court has inherent power to set the trust aside and remake the trust. The court can do a constructive trust. The court can revoke it. And I've had cases that I've litigated where we've gone to court and there's been trusts that were very expensive, very long, multiple trusts, multiple parties involved. And the court in equity said, I don't like this trust. I don't think it's fair. I'm going to set it aside. And Jim Cunningham, in one of his recent things, had Judge Reiser, who was formerly on the Ventura County Superior Court. And I had a case with Judge Reiser, a very big case one time, and he did just that. He set aside this pretty large trust because he felt it wasn't fair. And one of the reasons he did it was the person who was supposed to be the testator or settler, one of the questions was capacity. They had been involved in a train wreck, and he was very concerned that they lacked capacity and they didn't understand what they were signing when they set up the estate plan. But my point is, remember, whatever you are doing, if the matter finds its way into the courthouse, the judge has the authority in equity to do what he or she thinks is fair. And so when Jim talks about fashioning your will trust to disinherit somebody, if the court later looks at it, it's like Monday morning quarterback. It's not always fair. The settler's dead, the decedent's gone, and now the judge is trying to decide, well, what's fair here? What do I think should happen? And so sometimes the intentions of the decedent do not get carried out if for some reason it's not clear or it violates some part of the law regarding how they went about making it clear they didn't want property or a device to go to someone.
Yeah. So in getting ready for this, you and I have had previous conversations where we talked about, and a lot of times clients, in talking to clients, they go, that's ridiculous. And a client they'll say, like, I'm a software engineer or I'm an engineer, and this is not how the real world works. And they're absolutely right. Okay. There are two kinds of courts in the United States. We have courts of law, and you can think of the courts of law as being like, King Henry VIII and his court, and that's where the term comes from. The courts of law were the people who were in King Henry's court. Okay. So those were where you would have laws. Okay. There's this statute, a criminal statute that says if you steal a chicken, you get your, I don't know, you get flogged or something. I don't know. That's a court of law. And a court of equity is actually not the king. That's not the king's court. That is the church court. Now, this may seem really bizarre to you, but just imagine that there are really, it's a holdover from the Roman Empire, this sort of the Catholic Church before the split, and going back hundreds and hundreds of years, actually 1,000 years, right, Randy?
Yes.
Is when there were two types of jurisdiction. There was the jurisdiction of the earth, and there was a jurisdiction of the heavens. There was the jurisdiction of your property, and then there was the jurisdiction of your soul. And so there was this division, and the church had jurisdiction over matters of the soul. So where did court of equity come from, Randy? What
happened? And this is it's interesting. Keep this in mind. It's at the end of the day, it's all about fairness. And what had happened is when the Crusades started, a knight would say, the way you transferred real estate, you guys may remember from law school, those who aren't lawyers, is they would hand somebody a plot of dirt. And the symbolism was, I'm transferring title. At that time, they didn't understand this whole notion of equity and trust and what have you. So what they would do is the knight would say, I'm going to go to Jerusalem and fight for the crusade, and I need you to watch my property, my estate, in my absence. And they didn't really have a format to do that, so we'd hand them the dirt. Then if the knight survived the battles of the crusades, the knight would come back and say to that person, I want my estate back. Now imagine at this time, the person's had the estate, They've been living the high life for 5 years, 6 years, 7 years. They got all this money, all this property. Do you think they want to give it back? Generally, there were problems. So what would happen is if you went to the king in a law court, the law court would say, we don't have a remedy for you. You handed him the dirt, and under the law, he's now the owner. But in fairness, you'd go to the Ecclesiastes side and you'd say to the church, this isn't fair. I trusted this person. I gave them my property, and now they won't give it back to me. And so in fairness and in equity, the idea became, this isn't right. And we're going to step in. And even though the law says this, in fairness, we're going to overrule the law. And in equity, we're going to give you back your property.
Yeah. And the reason that works is because they were fighting the Crusades.
They were fighting the Crusades.
So you know what? It was a Crusades deal. Okay. And so that's where the point is. Here's the point of all this. How is it that we can live in a world where you can write down a will, or you can write it down in a will or a trust, and a court throws it out the window? I mean, that's the whole point of this, is it comes from stuff that happened 1,000 years ago. Okay.
That's right.
We have a couple of questions. So Denise asks, hey guys, thanks for the webinar. I have a litigious brother. Well, who doesn't? Who our family anticipates will contest our parents' estate plan and wishes. What strategies can we put into place to protect our parents' wishes? Their living trust has a no contest clause. Randy, you need to talk about those.
I will.
But we'd like to have more clauses or agreements in place while mom and dad are still fully competent. What about the no contest clause?
Well, no contest clause, it's in Latin, it's called in terrorem, which means terror. And all that means is the policy in California, the courts, when they decide this, they're really kind of torn. On the one hand, the courts want to enforce these clauses. And the clause basically says, hey, if you got a gift, even if you didn't get a gift, but you're going to challenge the estate plan, the will, the trust. If you challenge it and you lose any gift, any bequest, you forfeit. And the idea is to inhibit people from challenging a will and a trust. On the other hand, the law abhors forfeiture. So the courts in California don't like this clause, although they will enforce it. So they enforce it strictly. And in 2010, California did a big rewrite in this area with a new statute. They have what they call direct contests and indirect contests. But like in a will situation, it would be where someone says, I don't like what happened here. I think the will is a product of fraud, undue influence on mom and dad. If they lose that, and let's say they got a certain amount of money, that they are subject to forfeiture. So the thing that a lot of times people will do is if they're really worried, besides the no contest clause, and Jim mentions this a little later in our outline here, it's you say to yourself, well, how much money do I need to give that person? So that for them, it becomes too much of a risk to challenge the estate plan. And Jim, you can add more on that.
Yeah, I mean,
know you do this a lot.
You know, someone will come in, they'll say, I haven't heard from my daughter for 30 years. And, you know, she sent me one text 8 years ago and I just have no relationship with her. And I've tried to reach out and we tried to, you know, and she lives like 10 miles away, but she wants nothing to do with us. And so I'm going to disinherit her. Okay, well, we disinherit her. Well, but you know what? You know, you have an estate yet, you know, you're leaving $1 million to one kid and zero to the other one. You might want to leave the one kid you're not leaving anything. You don't want to leave anything to. Don't leave her half. Don't leave her 500,000. Leave her 100,000. Leave her 50. Leave her something where if she challenges the estate plan, she's forfeiting that. And I had heard, Randy, and I heard this in court years ago once, and I heard somebody else talking about it. There's a case in Texas. You know, it's one of these unpublished cases out there. There's a case in Texas that says if you receive a benefit from the trust, you are precluded or you're prevented from challenging the trust because you've actually gotten something from the trust. So I've heard that's, I don't know what case that is, but anyway. What if Anonymous asks, what if the original trust was drafted in California and the owner of the trust moves to another state? Can amendments be made to the trust in the new state? Well, the answer is yeah. Well, it depends. It depends if you can amend the trust or not. It really doesn't matter what state you're in. You do have to follow the terms of the trust. But I will tell you, if you do move to another state, I highly recommend you seek out a lawyer licensed in that state, that new state, and have your estate plan removed. Because I do know that the community property laws in Texas, for example, and a lot of people go to Texas, are different than they are in California. And I did a continuing education course on that. And I was I mean, I've been practicing law 25 years. I was shocked at how different it is. And I won't get into the ins and outs, but the point is, you really should be seeking out an attorney in the new jurisdiction. Carolyn asks, and Randy, this is one for you. Carolyn asks, am I required to leave to my one brother and two cousins? I mean, do I have to leave my estate to my one brother and two cousins? I have no children, no living parents. I have a husband. I am sole trustor of my trust. My husband currently is set up as trustee next in line. So does Carolyn have to leave anything to anyone, really?
If Caroline, if you have control over the asset, because see, if there's an existing trust, again, I don't know what the terms are, but let's just assume there's an existing trust. It's revocable, meaning it can be modified or changed, and that you have the power to disperse or dispose of assets the way you want, your personal assets or those that you control within the trust. Basically, you have the right while you are alive and while you generally are presumed to have capacity to dispose of your wealth the way you want to. One of the things that California has, and most states too, the presumption is that people have capacity and they know what they're doing, and that they have the right to dispose of their property the way they want to while they're alive and they have capacity.
Yeah, and it's interesting. There's no right to a jury trial in the probate court. Jury trial, I don't know why. Is it because juries came from the Vikings? I mean, I don't know.
I think the reason for that is it gets back to equity. Equity, so that people, when you're listening, lawyers get this. Equity is generally the domain of the trial court only, meaning your judge. No jury trial. Juries generally are reserved for legal claims, or like Jim said earlier, the law court. There are times, conservatorship, elder abuse statute in California, where by statute, the legislature has said, in these situations, we're specifically saying you can have a jury. But even in elder abuse cases, many times, by the time you get there for a hearing or a trial, you'll decide we don't really want a jury. Let's just let the judge decide it.
Hey, Randy, let me ask you, in your experience, when you have these contested probate cases, and when we say, by the way, when I say a probate case, I'm also including trusts, because even though you have a living trust, if there's a problem with it or somebody sues you or doesn't like you or files a trust contest, that's filed in probate court.
Yes.
So how many of these do you see resolve in a way other than the judge making a judgment, right? So how many of these are resolved before the very end when the judge says, okay, you get and you don't, or I'm splitting the baby or whatever?
I'd say this, in litigation generally, civil litigation would be an example. They always say 90% of cases resolve before they go to trial. In my experience, I've not seen that. I'd say it's more like 60, 70%. Okay. However, in the state of California, I think most other states are the same way. The probate and trust courts are very busy. So one of the requirements they're going to impose on the parties is to go to mediation. At some point after the action is brought before the probate judge, trust judge, he or she's going to say, I want you to go to mediation and I want you to get this case settled. Can they force you to settle? No. Can they force you to go to mediation? Yes. And what the courts will do many times is they don't want mediation to be too much of a financial burden, because mediators, Judge Reiss, who Jim had on recently, who's now retired, he's a mediator with an entity called JAMS. And they make good money now that they're mediators. And so it can be expensive. But to answer Jim's question, most of the time, virtually every case now gets ordered to mediation. Most of the time in mediation, they're going to resolve. It's a compromise. Usually nobody gets what they want, but I think most of the mediators with experience in probate do a pretty good job. Several of them, at least in Southern California, or former judges on the Ventura County Superior Court. Judge Johnson's one of them, Judge Reiss, I just mentioned. But it does make good sense to try to resolve it in a mediation, even if you think your case is very strong. Because as I said earlier, in the probate court, the judge acts in equity. And if the court sees a witness on the witness stand that he doesn't like or she doesn't like, the court could just decide one day, I don't like what happened here. It doesn't feel right to me. And the judge could completely go in a direction nobody thought the judge would go in. And so my recommendation would be try to get it resolved in mediation. And yes, most will resolve in mediation. The other thing I would just say before we end on this one topic, clients always say this to me: I want my attorney's fees. Every client, every time, every mediation says, I want my fees. The mediator usually tells them about 6 hours into the mediation before the end of the day, you're not getting your attorney's fees. So I always tell the clients before we start, I know you want your fees, but you have to realize you might have to give up on that to get the case resolved.
So just to be clear, mediation, let me do a little translation here. Mediation is not arbitration. Mediation is not court. Mediation is where many times, not always, many times the parties come together in one room and they meet, they have a meeting with the judge. And then these people go to that room, and then the judge or the retired judge sits with the other party, and then those people go in another room, and then they go back and forth. It's kind of like it's almost it's like when you're buying a car and you get in the room and the people are coming in and out. It's kind of like, in a way, it's kind of like that. Not probably a bad analogy, but my point is, it's not like a trial that you're putting on. This is a conversation that you have, and people are really ideally.
And the other thing I want to mention, Jim, too, is keep in mind, anybody who's listening, it's not an arbitration, it's a mediation. Mm-hmm. Everything's confidential.
Right.
So everything you say is confidential. And the judge who is overseeing the case is only told one of two things: we settled, we didn't settle. The idea is to keep it confidential so people are encouraged to speak openly to get the case settled.
Okay, John asks, my mother has a real estate portfolio worth mid seven figures. I'm doing the math. It's about 5 million. My brother has disowned her and me. He lives 5 miles from my mother and have not had contact for 8 years. My mother wants him to get nothing. She has a trust. What are the best mechanisms to have in the trust to prevent him from getting anything? So my mother has a real estate portfolio. My brother has disowned her and me. So the brother's out of the picture, and he lives 5 miles from mom. That was my example at the beginning, right? You live very closely. My mom wants him to get nothing. She has a trust. What are the best mechanisms? I think on that one, I will just say, John, you need to seek out the advice of an expert lawyer. You know, whether it's me, whether it's Randy, and we're both experts in our field, you absolutely have to go to an expert lawyer. Don't go to the lawyer around the corner. Don't go to the one who handles like drunk driving cases and car accident cases and immigration cases and has a neon sign in the front. You don't want to go to that person. You really need to go to someone who knows their stuff. But that one's a tough one, Randy, because there's a big, look, if mom has $50,000 in the bank and passes away, it's probably not going to go very far. But now you're talking millions of dollars. Any thoughts on that, Randy?
Yeah. When there's millions of dollars involved, a lawyer, even if the client comes in and says, hey, I have no money, I can't pay you, some lawyers will take it on contingency. And they'll say to themselves, you know what, there's a lot of cash here. There's a lot of assets here. It's worth taking a shot at it. And so when I was listening to this just now, Jim is right. You need to make sure you see somebody that is capable of giving you good, proper advice. I'll just tell you, for many years of working with Jim, he's that kind of a lawyer. We talked about the no contest clause earlier. Keep that in mind. But also the other thing I think is very important: how old's the trust? Has it been amended recently? Does mom have capacity? Why is there a division? Are there other siblings? Are there people who could testify later if mom were to pass away, that in a negative way challenge her capacity or her state of mind? And so these would be all the things that you want to take a close look at to avoid a problem. And here's the thing: sometimes no matter what you do, they're gonna sue. Jim and I talked about this before we started today. There's a phrase: anybody can sue you for anything. Now, does that mean it's justified? No. Does that mean it'll go anywhere? No, but they can. And the idea here is, if there is a lot of money involved, you want to avoid the courthouse if you can. And there's certain things you can do, and Jim touched on that earlier, but like Jim said, go see somebody like Jim, who's an expert, that can help you plan accordingly.
Yeah, Randy, you raise a really good point, and that's what's on the slide on the screen here. Your mother is presumed competent, however, and there's an asterisk. So here's what I've seen just on a short laundry list of things to consider. This is not advice. I mean it. So don't run out and do a bunch of stuff, okay? But here's I'm just going to tick down the laundry list of stuff. Number one, you could get her evaluated by a medical practitioner to say she's competent. That is a double-edged sword, because then the response is, well, why did you need to go get, there must have been a problem. You wouldn't have gone to the doctor if, so it's kind of like a catch-22. The other one is her writing a handwritten letter about why she wants to leave everything to you and not your brother. Again, double-edged sword if she puts invalid reasons in there, or she says, my son never saw me for 5 years, blah, blah, blah. And then your brother shows up and he says, well, what's mom talking about? She was off her rocker. I came, when you weren't there, I came by every week and saw her and we spent 2 hours together, but she's not there to say that's not true. I mean, I'm just kind of thinking out loud here, Randy, but this, by the way, this is why you need to seek out an expert lawyer.
The other thing too, that when Jim mentioned, hey, go have your mom evaluated. It's beyond a double-edged sword. You could go have her evaluated and they might find that she lacks capacity. Sometimes in their background, or treating physician, sometimes family members don't know this, does these mini mental tests on their patients, right? And they'll have a mini mental tests in there from like 3 or 4 years earlier that shows they failed it, or they had incapacity of some sort. We're going to talk about this a little later in our presentation today. California courts have kind of a sliding scale on this now. But the point is, and this is what Jim was saying, when you start looking at your mother, when you start saying to yourself, the age is important, her state of mind's important, who has influence over her? Does she have the ability to manage her own financial affairs? Because it's just not only financial affairs, but can she manage her health, her welfare, her living? And these are things to consider. And the main thing you need to look at this is if your mom were to pass, went to an attorney and they were thinking, well, how are we going to best challenge this? These are the checklist of items they're going to go through to determine whether or not there's merit or any chance of success on the lawsuit. And that's why better to do it now while you still have your mother alive, to hopefully adequately carry out your mother's wishes. Because at the end of the day, if your mother really wants to disown your brother, then you want to do what you can with the help of a professional lawyer to carry out her wishes. Because at the end of the day, what the law is saying continuously throughout all the cases, we want to recognize what they want, meaning mom or dad, and we want to ensure that their wishes get carried out legitimately.
Yeah, and Randy, you mentioned Judge Reeser's video. I really think if you guys are the people watching this, I would go back and look at Judge Reeser's video, because we did cover a lot of this, and this is a lawyer's perspective, and this is not duplicative. It's like looking at it from another angle. You really need to listen to what Judge Reeser had to say. He also teaches the probate judges. He's one of the judges go to college when they're appointed judge, and they go to judge school. He's one of the teachers for probate. So he teaches the judges throughout the state. And something else to bear in mind, it matters what county you are in. If you're in Los Angeles County, you effectively have specialist judges. If you go to a probate judge, that's all they're handling. I mean, they might handle family law, but Randy, most of them are just handling one area.
Yeah.
You go to Glenn County, and I'm not throwing shade on Glenn County, but you go to these other smaller counties, these more rural counties, and you may have one judge in the whole county, right? Or you may have 2 or 3, and they might hear probate on Tuesday morning, and that's it. And then they're moving on to criminal law and family law. So there is a certain, it's just a difference. And I'm not saying one judge is better than another judge, but these certainly are different. Now, Denise asks, can my litigious brother contest real estate held in entities such as an LLC, corporation, or limited partnership? Randy, I think everything's in play, isn't it?
Well, just let me answer it in the most simple way I can. He can challenge the way those assets are held. But might be a number of ways he could do it. One, he could claim that the entity was set up for some fraudulent or nefarious purpose. For example, avoiding a judgment, avoiding some type of a contractual agreement between family members or third parties. And that's what we call a fraudulent transfer. The other way would be that there wasn't sufficient consideration given for the asset. Again, I don't know how these LLCs were set up, but consideration would be, well, this $10 million piece of real estate found its way in this LLC, but nothing was paid for it. Well, was it a gift from the person who owned the real estate, for like a father or a mother? I mean, how did it get in there? Because remember, these limited liability companies are creatures of statute, meaning the state recognizes them as a legal entity. But that's a little different than putting something into a trust, let's say, which is an estate document. Again, I don't want to go too far with it, but I would just say that sometimes when you look at these situations, the first things you got to think about is how the asset get there and why is it there?
Yeah, standing basically is skin in the game. If you hear these legal terms thrown around, I can't sue on a piece of property I don't own, that I don't live in, that I've had no connection with. Okay. I mean, there are certain instances where, the public has an interest in whatever, but I'm just saying broadly, you have to have skin in the game. Okay. There has to be some type of nexus or connection or potential damage that you're suffering. And that's part of that. Okay. So Anonymous asks, are flags raised if amendments to trusts occur after a certain age? Some say amendments cannot be made after age 80. Is that true? If you're over 80, can you amend your trust?
You want me to answer that?
Sure.
I think you can.
Is there a but after that, or no? I think you can.
The only hesitation I would have is the thought would be common sense. Okay, you're starting to lose your capacity. But I would say in most instances, unless there's evidence that the person does not have capacity, we talked about that earlier at Probate Code 811, then I think if I were a judge, in my experience of almost 40 years of doing this, the court's going to say, hey, they have the right to make a will and a trust at age 80, unless you show me that they didn't know what they were doing or couldn't comprehend the effect of their act. But Jim, you do this more than I do. What would your answer be?
Well, first of all, 80 is kind of young. So if you're 80, you probably haven't heard that 80s. I mean, first of all, it depends on the 80-year-old. But I met with some clients a while back, and I was supposed to meet with a couple, and we like it when the both spouses come in. And so the husband, in this case, the husband comes in, he's 80, his wife's 82. She doesn't come to the meeting. And I said, man, and I'm like, gosh darn it. We can't really have an effective meeting without both spouses here. And I see his wife's 82, and he says, well, she's taking care of her father. And I was like, what? She's 82. I said, her father, how old's her father? And he goes, oh, Orville? He's 106. He was named after Orville Wright. I mean, this is,
Incredible.
It's amazing.
Incredible.
So I think it depends on the person. I've met with some people who are 70 who are just completely out of it. And there are other people who are 95 who are sharp as a tack. I think the guy who prosecuted the Nuremberg trials is still in practice. He's like 98 or 99 or something. I don't know. So John asks, why isn't a trust a legal entity? What can a legal entity do that a trust can't do? Kind of an interesting question. I think a living trust is considered an alter ego, like the government kind of disregards. I will say in general, for revocable trust, your typical living trust, for many purposes, the government, the state government taxing authorities, they ignore the trust, but not for everything. An irrevocable trust can have its own taxpayer identification number, but an entity is typically a corporation, a partnership, or an LLC. That's typically what an entity is. So, what about let's talk about the drafting lawyer, and then if you guys have any more questions, we're about ready to wrap it up. What about the drafting lawyer? So, if a client hires a lawyer, who's the lawyer supposed to be looking out after? And I ask that because, mom and dad come in and they have 3 kids. And as the lawyer, I'm thinking, okay, I have to do what the parents want, but also the kids might not be happy with the outcome, and they might sue me as a lawyer. Do I owe a duty to those beneficiaries? If you can walk us through that, Randy?
Yeah, I would say immediately that the lawyer does not. However, remember what I said at the beginning of our conversation today. If you are the lawyer and you are retained, let's say by mom and dad, and they ask you to put together their estate plan, your relationship runs to them. It doesn't run to their children. It doesn't run to their siblings. It doesn't run to anybody but them. That means that when you are meeting and speaking with them, the requirement of confidentiality applies. So when you're talking to them, unless they tell you otherwise, your conversations are privileged and private. So if their adult children happen to contact you and say, hey, I heard mom and dad are doing a trust and a will, I want to know about it. Unless you're giving consent to talk about it, you can't disclose that to them. You can't tell them about the drafting. You can't tell them what's in there, nothing. Now, sometimes the parents will say, it's okay, you can talk about it with my children. But their big issues arise when the kids start to get involved with the drafting, especially if they're going to get a disproportionate share of the trust or the estate through the will or the trust. Because one of the issues that comes up is undue influence. Were they there in a drafting session? Did they show up and mom and dad sign? And there's court cases that talk about the level of interfacing with the lawyer many times will determine whether or not that will or the trust should be set aside. And so my advice would be, if you are an attorney and you are meeting with the client, unless they tell you otherwise, it's confidential. You don't say anything. You carry out their wishes. Now, as I mentioned, keep in mind how the legal relationship is created and how it occurs. You don't need to have a signed engagement letter for it to occur. You don't have to accept cash or be paid any money for it to occur. You don't need to send them a billing statement for it to occur. It can occur if you speak with them and the person you're speaking to thinks they're in a confidential relationship with you and that you're giving them advice of a legal nature for their benefit. So again, be very careful here. And you know, if you do have questions about it, I would just invite you to, again, take a look at the law and just be aware of this idea of privity of contract. But basically all that means is, where does your relationship run?
You know, I will also say, for those of you who hire a lawyer or are going to hire a lawyer really for anything, sometimes this does not happen that often. And Randy, I don't know if it happens in your practice, but sometimes people will say, well, these are the facts I want to give you, and answer this question based on this limited set of facts. And then I'll say, well, what about this? Do you have this type of an asset or what? And they say, no, I don't want to tell you that. I just want you to answer this based on this limited facts. I will tell you that really it annoys me, because as a lawyer, our training is to ask a bunch of questions. Like, we may not know the answer to it, but we really do need to find out. And so I would be totally truthful with your lawyer. You should be truthful with your lawyer, because there is an attorney-client privilege here, right? If you've hired a lawyer, you have the engagement or it's attached or whatever it is, but don't hold back with your lawyer, because that really only is going to hurt you. If you think, well, if I don't tell my lawyer, it won't come out. I will tell you, when people die, something you need to bear in mind, everything sees the light of day. It all comes out. Nothing is hidden. You better be forthcoming with all the information. When I'll meet with people and I'll see two spouses with two kids, I will ask them, do you have any other children? And they go, well, I just wrote I wrote those two children there. It's like, no, do you have any other children? Because if you have an extra kid out there, right, somewhere, and it happens, that child, unless they're mentioned in the will, if you just don't mention a child, that's called a pretermitted heir or an omitted heir or a forgotten heir. They can come forward and they can make their claim against the estate. So it's very important that you be completely forthcoming, even with all the sort of secrets. So we have a question. Judge Reiser, how do you spell his name? R-E-I-S-E-R. Glenn, G-L-E-N-N. Two N's, R-E-I-S-E-R. I'll tell you a funny story, a quick story about this. I was in court years ago, and Randy, I think you'll appreciate this. There was a contested probate case, and this attorney stands up and he says, Your Honor, I've seen your tentative ruling. And in probate, a judge will say, this is how I'm going to rule, and they'll post that a couple of days before. And he says, Your Honor, I've seen your tentative ruling, and I want to tell you, you can't rule that way. Which, if you know Glenn Reiser, you would never tell that to him. He says, you can't rule that way because the Supreme Court of the state of South Dakota has ruled the opposite. And so they said left, you're saying right. And here's the power of the court of equity. Judge Reiser, he says, I went online and I Googled the population of the state of South Dakota and the population of the state of Ventura County. There are more people in Ventura County than South Dakota. So I'm ruling, the opposite of what the Supreme Court, and this attorney was jumping up and down, not screaming, pretty animated, like, you can't do this. You can't do this. But that is the power, Randy, of a court of equity.
That's true.
They can disregard. I mean, I'm just going to speak plainly. Now, this may not be legally, if you're a lawyer, you're going to be like, they can disregard the will, they can disregard the trust, and frankly, they can disregard the law. Okay. And they can leave it as they see fit.
Yeah. Let me say this too. And the lawyers out there appreciate this, especially if you're litigators and you do any appellate work. Because it's a court of equity, the judge makes his or her decision based on their discretion. So if you want to appeal it, take it up on appeal, you pretty much have to say the appellate court, they abuse their discretion. And the appellate court, most of the time on that standard, is not going to reverse the judge, particularly in an equity situation. And so Jim is right. They have a lot of authority, but at the end of the day, I would just say this, their goal, if they're doing their job appropriately, and I think honestly, most judges who I have seen in the probate courts really want to do what's right. They strive to do what they think is fair. They really do. And so at the end of the day, when you do your gut check, if you're thinking about litigation, you need to say to yourself, which side are we on? Are we on the side that's more fair than this side, or is there a legitimate dispute here? Because when it gets to the probate court, the judge is going to make a decision on what they think is fair. And once they make that decision, their rulings generally are going to flow from what they think is fair.
Anonymous asks, how long does your firm, I guess, I don't know, me or you, Randy, how long does your firm retain a copy of a will you drafted? I will say that there are two types of files in our firm. They're the ones that we work on ourselves. And those we typically scan documents and retain them for a period of time. And then either the client directs us to delete them or they don't. And then the other one is firms that we've acquired, and our firm has acquired or merged with 20 now other practices. And so sometimes we have a copy, sometimes we don't. Sometimes documents are shredded. It's just kind of a hodgepodge. But if you want to know if we have a copy of your will, you could certainly call us. And if you're, someone on here who's trying to sue somebody where we've done an estate plan for them, just disregard everything I said. Kev, do you guys retain originals, Randy, or not?
Generally, we don't do the drafting. And if we are involved in the drafting, I usually have a law firm, Jim, with you, and we would have your firm retain the originals.
Okay. Lawyers can have an original retention policy or a retention or non-retention policy for original documents. That's kind of the old school way, is to retain the originals. It would just be too much paper for us. Kevin asks, I'm disinheriting my estranged daughter, now 5 years. I am in my mid-60s and am gifting my two sons 15% each and the balance to charity, 5% to my daughter to discourage contesting my will. Will the gifts to charity affect the ability to disinherit my daughter? So 15 to the two sons, 5 to the daughter, the balance to the charity. What do you think about that? So 35% to the kids, 65% to charity.
My sense of it is that there's nothing that I'm hearing that indicates to me that a reviewing court would see that as being improper. Again, you have the right as the owner of this property to devise it, meaning gift it the way you want to. The fact that you elected to give your daughter something is probably going to help you if there's ever a challenge. Also, your boys are only getting 15%, so on a percentage basis, I don't think it looks too unreasonable. But I also want to say, if you had decided to leave everything to charity, 100%, you have the right to do that if you want to. And there are times where some of my clients, Jim clients too, where the person will say, hey, my kid's got a lot during lifetime. I gave him tons of lifetime gifts. There's a lot of estate planning, wealth asset transfers. Jim does a lot of that, tax planning, where the lifetime gifts are all happening. That's one, Proposition 19. Jim's got that happening today. But the point I want to stress in answer to your question is, it seems to me reasonable given that everything else in your trust is set up properly.
And Denise asks, would it be helpful to have my litigious brother sign a non-disclosure agreement to prevent a contest? If not, is there another document that would work? I mean,
one of the things
I
you have
don't
to
know.
think about, it's an unenforceable agreement to have somebody waive in advance violations of their rights. So let me say it this way. It's under the policy of all states, and in California for sure, you can't say to somebody, I'm going to give you $100 and you're going to waive any right to sue me if I decide later to punch you in the face. So the thing you have to be careful of here is, if you want them to waive a right, sometimes it's better to have them confirm what you're doing versus waiving a right. Confirmation would be where they say, I acknowledge, I consent, I agree, and I affirm that I accept this as my full and complete whatever gift it's going to be. And a gym would be very well to do it like a draft of something like that. But again, there's just these kind of nuances in how you do it as to whether or not it would be enforceable or not.
Sometimes conflict is inevitable. Sometimes there's nothing you can do. And you know what? Sometimes it's worth it. And I think sometimes it's not. And, you know, I think that there are reasons why people sue. There are reasons why people get disinherited. I mean, maybe, you know, maybe your brother didn't get the red 1962 Schwinn bike for Christmas, right, in 1962, and he's been mad ever since, and he's bitter. Maybe it's just the fight is inevitable. But to your point is, how do you make it harder for him? Can you build a wall and a moat and put some alligators in it and some water and a fence and another wall and another moat? Yeah, there are a lot of structures you can use for that. Let's take this as our last question, and we'll wrap it up with this. And this is a complete double-edged sword. Would doing a video help in case of a contest? What do you think, Randy?
Okay, there's a doctrine in the law called certificate of independent review. All the lawyers out there, you're going to know this. And what that's about for the lay people out there is that if you know there could be a challenge later, the law says, look, you can have an independent person meet separately with mom or dad, and they can interview them and ask them, do you know where you are? Who's the president? You know, are you aware of what you're doing? Do you understand this, understand that? And there's a couple of views on whether this should be videoed. Jim and I have talked about this, and we've generally, I think our consensus has been, don't videotape it. Have the person who does the interview sign a certificate. Usually they're an attorney that you know. Again, they're independent. They're doing their own review. Because the thing about the video is, if you do the video and something weird happens in the video, then you're stuck. Because if you destroy the video, then later, if there's a challenge, somebody's going to say, well, why did you destroy the video? If you keep the video and then they see it, then it's bad too. So Jim and I would say generally, when we've talked about this, our consensus has been, don't do the video. But I'll turn it over to you, Jim. What are your thoughts?
Yeah, I think it depends. If it's almost like if there's a need to do a video, it's probably a bad idea.
Yes.
So, right?
You know it's a bad idea because you're thinking about doing the video.
Yeah, right. So the other thing too is generally the lighting is really terrible. And I mean, we've been doing Zoom now for a year with COVID, but the lighting can be really bad. And the sound can be bad, and the person can look disoriented. And the problem with video is you're only getting this much of the world. And so, you have a context problem, but I think it's a double-edged sword. But Randy, I agree with you. I would rather have a lawyer testifying that they met with a person.
Yes.
And she was fine, and this is what she wanted to do, rather than oh, well, I saw her in 2 minutes and 13 seconds in the video. She looked like she didn't know where she was, and she looked confused, right?
Definitely better to have the lawyer do it and have them sign an affidavit, or declaration, which they'll do. But you have to just keep in mind, for those of you who are not litigators, the lawyers, litigation it's kind of like Private Ryan when they hit the beach in Normandy. You know, you hit that beach, and if you can get past that beach, it's a miracle. Because sometimes what happens is you get it in the courtroom. Remember, these judges, a lot of them have been civil judges. Like Jim said, they rotate. And so they're going to be pretty experienced with the rules of evidence. They're going to be experienced with how trials are to be put on. And if you get in there and you make the mistake, for example, maybe using a video like this, a lot can go wrong very fast. So again, I would say, all things being equal, I would not be in favor of videotaping someone unless there was a very good reason to do so.
All right. Well, thank you so much, Randy.
You're welcome.
Please subscribe to our YouTube page. We got a lot of videos coming up this year. We got the whole Prop 19 ending. We've got Biden's whole tax plan coming up. And if you want to learn more about a judge's perspective, go on our YouTube page. We've got a recorded webinar with Judge Reiss. And here, of course, you can visit us on our webpage. We got a lot of great content there. And there's a place to book a consultation as well. We have one more. Oh, thank you. All right. All right, Lola. Hey, thanks for joining us today. All right, Randy, thanks. And
thank you.
Feel free to reach out to us, and have a great day, guys.
Thank you very much.